Okay, let's continue on our discussion on who are the principals. So we have principals, accomplices, and accessories. So let's continue with our discussion on principals by inducement. I think I have gallery. Wait. Share ko na lang yung codal provision. Let me just open the codal provision. Okay, ano lang, off lang. Yeah. So there's a mark question insofar as a principal by inducement is concerned. So yun, can you see this class?
Yes, sir.
Okay. A asks, A asks B to kill C because of a grave injustice done by A. Okay. Done to A by C. A promised B a reward. B was willing to kill C, not so much because of the reward promised to him, but because he also had his own long-standing grudge against C, who had wronged him in the past. If C is killed by B, would A be liable as a principal by inducement? I emphasized this a while ago. Suggested answer, no, A would not be criminally liable as principal by inducement because under the RPC, such inducement must be the determining cause of the commission of the crime by the material executor. Di ba? May dalawa yan. It must be with the intention of procuring the crime and also it should be the determining cause for the commission of the crime. In this case, the reward A promised to B, which constitutes as the inducement, is not the sole determining factor or reason which made the latter kill the victim. B committed the crime. Why? Because there is a long-standing grudge against C who had wronged him in the past. So, yun ang tatandaan nyo. If you had other reasons to do the crime other than the inducement, then this would not be considered because it should only be the only determining cause why the crime is committed. Kung bonus na lang at meron silang existing grudge between the two, then this should not be considered as such. Okay. Let's continue with whiteboard. Yeah. Let's go to principal by indispensable cooperation. So, tingnan nyo yung isa direct participation, isa indispensable cooperation. So pareho silang principal pero iba yung acts niya, di ba? So ito, he must be present. Ito rin must be present as well. But itong indispensable cooperation, without his cooperation, the crime would not have been committed. If the crime would be committed even without his participation, then he is not deemed as indispensable. He would only be deemed as an accomplice. Kasi dapat yung magic word ay indispensable. So pag hindi indispensable ang kanyang participation, it will not be considered. Diba, sa example is when A A, B, and C intended to kill X. Island 1, they're all in Island 1 and Island number 2, si X. So separated by C sila. And the only way to get to Island 2 is the motorboat owned by X. Sabi ni A, B, and C kay X, we intend to kill X. Ibahin natin pangalan. Kay Y, we intend to kill X. And we cannot go to this island number 2. We want to borrow your boat. And this is the only way so we can reach island 2. So Y lent his boat. No, binigyan niya yung susi. So they're true enough. A, B, and C they were able to go to island 2 because of the motorboat owned by W. And because of that, they successfully killed X. Patay si X. They returned and it was, sabi niya, okay, thank you for giving us the only boat, because without your boat, we could not have killed X. Okay, what is the participation of A, B, and C, and Y? A, B, and C who went to Island 2 and actually killed X will be liable as principals by direct participation. Y would be liable instead for as an indispensable cooperation. He's also a principal. All of them are principals. But I will be, Y's participation is distinct. Why? Because he's not a principal by direct participation. He is a principal by indispensable cooperation because his act, without him agreeing that his boat to lend his boat, A, B, and C would not have committed the crime. Meron ding example niyan eh. Ibang cases, no, si A at B, si C ni rape, intent of raping C ni B. So ang ginawa ni A is to hold the both hands of C. Hinawakan niya yung parehong kamay ni C, and because of that, B successfully raped C. Now, sinabi ng Supreme Court, participation ng A is a principal by indispensable cooperation. Without him holding the hands of C, then B would not have committed the crime of rape. In the same manner, ganun din dito sa sa illustration. Without Y lending his boat to X, the crime would not have been committed. However, if there are several persons who own a motorboat instead of Y, meron din si Z, meron din si L at F, napili lang nilang tatlo si Y. Pero pwede rin silang may mga ibang motorboats also owned in the island. Then I would not be a principal by indispensable cooperation, but merely as an accomplice. So tatandaan nyo, his participation must be indispensable. Okay.
Din, pwede po magtanong?
Yes.
Alam po ba ni Y na papatayin ni ABC si X nung pinahiram niya yung boat?
Yes. Alam niya yun. Pero hindi siya co-conspirator. Mamaya, you would be able to know the difference between a principal from that of an accomplice. Tandaan nyo, pagka may principal, pag direct participation, there must be conspiracy. When you talk about conspiracy, there must be an agreement. Eto, si accomplice, meron siyang knowledge. Alam niya yan. But he did not participate. He's not a co-conspirator. He agreed. He merely approves the same. By previous or simultaneous acts? Sige. We will go into that later on. Let's go to the caudal provision. Punta na tayo sa accomplice. Ano sinasabi sa accomplice? Accomplices are those who not be included in this article cooperated in the execution of the offense by previous or simultaneous acts. So, hindi dapat siya, and who is an accomplice? An accomplice should not be a principal by, dapat his act should not fall under a principal by direct participation. His act will not fall under inducement. His act would not fall under indispensable cooperation. So, under direct participation, dapat hindi siya co-conspirator. Hindi siya kasama sa nagplano. Hindi siya nagplan. Hindi siya nag-agree, no, sa criminal resolution nila. Pero maaaring alam niya, no? He cooperated in the execution of the offense. How? By previous or simultaneous acts. So that is things that has to be considered. Participation of an accomplice presupposes the commission of the crime by a principal by direct participation. The principal element of every punishable complicity consists in the concurrence of the will of the accomplice. So, meron ko a concurrence of the will of the accomplice with the will of the authors of the crime. And the accomplice cooperates by previous or simultaneous acts, no? So kaya nga dapat alam nyo how to determine kung may conspiracy o wala. When there is no conspiracy between or among the offenders, but they were animated by one and the same purpose to accomplish the criminal objective, those who cooperated by previous or simultaneous acts cannot be liable as principals, but as an accomplice. In case of doubt, paano sir? Hairline lang ang difference yan. In case of doubt between a principal or an accomplice, the participation of the offender will be considered that of an accomplice rather than that of the principal. Kung ang participation niya ay hindi disclosed, he is only an accomplice. Okay? A person who assists one who commits the crime, no, and who knows the latter's purpose, no, but whose participation is not disclosed, may not be considered as a principal, no, because his acts are perhaps neither direct or absolutely necessary for the commission of the offense, nor do they include the inducement. Pag hindi malinaw dun sa tatlo, most probably accomplish siya. Kaya nga in case of doubt, dapat he will be deemed as an accomplice rather than that of principal. So again, importante, an accomplice does not have previous agreement or understanding or is not in conspiracy with the principal by direct participation. He does not enter into a conspiracy with the principal by direct participation. Wala silang previous agreement or understanding. So, what are the requisites? Ito tatanda niya. In order that a person may be deemed as an accomplice, the following requisites must be concurred. Number one, that there be a community of design. That is, ano ibig sabihin yun? Knowing the criminal design of the principal by direct participation. Alam niya na merong plano. Pero hindi siya participant, ha? Hindi siya hindi siya kasama sa planning. He knows the criminal design of the principal by direct participation, but his act is what? He concurs with the latter in his purpose. He concurs or approves. No, yun ang ano yan. Hindi siya nag-agreement. Wala siya sa agreement. Pero nung nalaman niya yung criminal design ng mga principal, okay yan. Di ba? Sabi niya, he concurs or approves with the latter in his purpose. And that what? Yung magic word. No? He cooperates in the execution of the offense by previous or simultaneous acts. No? How does he cooperate? No? With the intention, his intention of supplying material or moral aid in the execution of the crime. No? And that there may be a relation between the acts done by the principal and those attributed to the person charged as an accomplice. So ano ibig sabihin ng isa? Community of design. Number one, that note that before there could be an accomplice, there must be a principal by direct participation. So hindi naman pwedeng accomplice na walang principal by direct participation. Merong principal by direct participation. Pero yung criminal design nag-originate kay principal. The principal originates the criminal design. The accomplice merely concurs with the principal in his criminal purpose. Okay? That the cooperation that the law punishes is the assistance knowingly or intentionally rendered, which cannot exist without previous cognizance, without previous knowledge of the criminal act intended to be executed by the principal. So paano nalaman ng principal yung knowledge of the criminal design? Paano nalaman ng accomplice yung criminal design ng principal? How can an accomplice acquire the knowledge or criminal design of the principal? Na other two ways, when the principal informs or tells the accomplice of the former criminal purpose. Gusto kong patayin si X. Yun. Pero nagplano si principal, hindi siya, no? Okay. O kaya nakita niya, when the accomplice saw the criminal acts of the principal and he concurs by previous or simultaneous acts. Pero tandaan nyo, pag hairline lang ang difference eh. Pagka merong agreement, ibang usapan yun. Now, kung wala siyang, sir, paano yun? He has no knowledge of the criminal design of the principal. Then, most probably, he's not an accomplice. No knowledge of the criminal design of the principal, no? He's not an accomplice. Ito yung madalas itanong sa bar. Hiniraman ka ng when the owner of the gun knew that it will be used to kill a particular person. Papatayin ni principal yung victim. No, meron ng owner yung humiram ng barel. Papatayin ko si X, sabi niya. Matatindi na atraso, pahiram ng barel, no? So ang ginawa, pinahiram yung barel. Kaya lang ang humiram sa kanya, no, hindi binaril yung si X. Binaril yung ibang tao, no? Pinatay yung ibang tao using the gun. Pero ang sabi niya, papatayin niya si X. And pinatay niya, pinahiram siya ng gun. Pero ang pinatay niya si Y. Okay? Will the owner of the gun be deemed as an accomplice? The owner of the gun is not an accomplice as to the killing of the other person. So, this was asked in the bar examination. Okay, like the principal by by cooperation under paragraph 3, the accomplice cooperates with the principal by direct participation. Etong medyo ano diyan eh. Merong principal by direct participation, okay? So titingnan mo kung may conspiracy, principal siya by direct participation. Kung wala, most probably an accomplice ka. Ano pa yung sa nakakalito dito? I-determine mo kung whether he's a principal by indispensable cooperation or an accomplice. Kasi pareho silang nag-participate. Tatandaan nyo lang, yung participation ng accomplice is only necessary, not indispensable. Meaning to say, the crime will still be committed even without his participation. Okay? Pero tatandaan nyo, kahit necessary yan, kung merong conspiracy, principal siya. Di ba? Ano bang example ng cooperation by accomplice? Previous acts. Lending of a pistol, yung sinabi ko sa inyo. Knowing the criminal purpose of that person. Yung isa, gustong rapein si yung biktima, okay, yung pharmacist, knowing the criminal purpose of another, furnish him with a drug, no, which will put the victim to sleep in order to rape her, no? Kasama din doon. Kaya nga very hairline difference lang between the principal by yung conspiracy sa kaya accomplice eh. Kaya in case of doubt lang, accomplice siya. Yung by simultaneous acts, the defendant who held one of the hands of the victim and tried to take away the latter's revolver while the co-defendant was attacking him is deemed to be an accomplice. When the acts of the when the acts of the accused are not indispensable in the killing, they are merely an accomplice. So yung accomplice, sinuplayan niya yung principal with material or moral aid for as long as without conspiracy. The accomplice merely supplies the principal with the material or moral aid without conspiracy with the latter. And of course, yung the wounds inflicted by an accomplice in crimes against persons should not cause the death of the victim. Hindi dapat equal ang participation niya to that of the principal. The third requisite, an accomplice may be liable for a crime different from that which the principal committed. There must be a relation between the criminal act of the principal and the act of the one charged as an accomplice. Ang participation ng accomplice should dapat not equal or greater than that of the principal. Hindi dapat pareho o mas higit yung ginawa ni accomplice from that of the principal. Okay? Halimbawa, Si A, pinagsasaksak si X. The wound that inflicted, please mute lang Mr. Miranda. The wound inflicted by A against X is a mortal wound. Dumating si B. Si B pag sinabing pinagsasaksak si X sa different parts of his body, and it is deemed to be a mortal wound that he inflicted. Si B dumating, he hit X with an iron pipe sa head until lumabas yung utak ni X. So, the wound inflicted by B is a mortal wound. So, since parehong in-inflict ni principal at ni accomplice ay mortal wound, ay ng tao claiming to be an accomplice is equal to that of the principal, then he is not an accomplice. He is also a principal because the wound that he inflicted is the same as that of the A. Meaning to say, it caused the death of X as well. Now, kung ang ginawa ni B is sinampal lang si X, no? He merely concurs with what A did when he slapped the face of X, or he kicked only the head of X. Sabi niya, buti nga sa inyo, namatay ka, o mamatay ka. Then he will only be an accomplice because his participation is not equal or greater than that of a principal. So, ayan ang magic dyan. Anong trick? Less than nga ang ginawa niya, pero may conspiracy naman, ibang usapan yun. He's a principal by direct participation in that case. Let's go to Caudal. Let's analyze the bar problem. Okay, in 2009, Ponciano borrowed. Ito yung kuwang-kuha doon sa principle na kinuha natin na diniscuss natin kanina. Ponciano borrowed Ruben's gun, saying that he would use it to kill Freddy because Ruben also resented Freddy. He really lent his gun but told ba siya na pagkabaril mo kay Freddy, isolin mo kaagad . Later, Ponciano killed Freddy but used a knife because he didn't want Freddy's neighbors to hear the gunshot. Iba naman pala ito. So hindi gun ang ginamit, no? Gumamit ng knife, pero he borrowed the gun. Okay? What if any is the liability of Ruben? Ruben cannot be a principal because there is no plan or agreement to kill Freddy. There was also no inducement in the facts given. Moreover, his acts is not indispensable as Ponciano actually killed the victim with a knife and not with a gun that he provided at all. If only he concurred with the criminal design of Ponciano by providing him with a gun. Would your answer be the same if instead of Freddy, it was Manuel, a relative of Ruben who was killed by Ponciano using a gun? No, the answer will be different. Ruben lent his gun purposely for the killing of Freddy only, not for any other killing. Ponciano's using Ruben's gun in killing a person other than Freddy is beyond Ruben's criminal intent and willing involvement. Only Ponciano will answer for the crime against Manuel. It has been ruled that when the owner of the gun knew that it will use to kill a particular person, but the offender used to kill use the gun to kill another person, the owner of the gun is not an accomplice as to the killing of the other person. while there was a community of design to kill Freddy between Ponciano and Ruben, there was none with respect to the killing of Manuel. Okay? Let's go to an accessory. An accessory is one having knowledge of the commission of the felony. May knowledge siya. And without having participated therein as principals or accomplices. Without participating as principals or accomplices. Meaning to say, dapat yung act ng accessory hindi magfa-fall under the three instances ng principals. Hindi rin dapat mag-fall siya as an accomplice, no? But he has knowledge of the commission of the crime without participating as a principal or as an accomplice, takes part subsequent to the commission of the crime by profiting from the effects or assisting the offender, okay, by the effects of the crime. Let me check. Again, he has knowledge of the commission of the crime without taking part as principal or as an accomplice. Okay, takes part subsequent to the commission of the crime. So, ano yan takes part subsequent to the commission of the crime. So, after the crime had been committed, by profiting from the effects of the crime. Okay? Yung diniscuss natin kanina sa caudal. Second, by concealing, profiting from the assisting to profit in the effects of the crime by concealing or destroying the body of the crime. Is it limited to the body of the victim? No. Ano ba yung body of the crime or corpus delicti? Corpus delicti means that the fact that a crime has been committed. So it includes it includes the body of the victim and the knife use and other things that would other pieces of evidence that would support that indeed a crime had been committed. So kung tinago niya yun or he destroyed it, then he will be liable as an accessory. Okay? And pangatlo, ito nakakalito, by harboring, okay, or concealing or assisting in the escape of the principal. For the crime of TPMA, treason, parricide, murder, attempt on the life of the chief executive, or is known to be a habitual delinquent. Okay. This is applicable if he is a private person. Ito na lang natin lagay. If he's a private person, escape of the principal charged with treason, parricide, murder, attempt on the life of the chief executive, or is known to be a habitual delinquent. If he is a public officer, then wala nang there is no limitation as to what crimes for as long as there is an abuse of his public position or public function. So what must you consider here? You must consider escape of the principal. We're not talking about the escape of the unaccomplice. If the person who escaped is an accomplice, then this is not applicable. Escape of the principal. Pag private siya, yung person charged is dapat guilty siya ng treason, parricide, murder, attempt of the life of the chief executive, or is known to be habitual delinquent. If he's a public officer, then there should be an abuse of his public position. Any crime. Okay? So how do you distinguish this from an accessory from that of the anti-fencing law? You always coordinate this with the anti-fencing law. Kasi sa anti-fencing law, nag-profit din siya from the effects of the crime, di ba? The third one, harboring, concealing, or escape in the principal. How do you differentiate this from obstruction of justice? So this is SPL. The other one is RPC. Accessory is under the revised penal code, di ba? Profiting from the effects of the crime or assisting to profit. Accessory is a crime punished under the RPC. Balik tayo sa basic distinction na sinabi ko before. Anti-fencing law is punishable under the special penal law. An accessory is punished under the RPC. If a person is found to be an accessory, he is entitled to a reduction of penalty 2 degrees lower than that imposed upon a principal. Diba? On the consummated stage. Yung anti-fencing law, walang reduction of the degree because there's a specific penalty provided under the special penal law. Next, third, since it is punishable under the RPC, then good faith is a proper defense. And SPL, anti-fencing law, since it is a special penal law, good faith is not a proper defense. Yung mga basic differences, no, unahin muna natin yun. Okay, once we lay down the basic differences, then pasok ka na. Sa anti-fencing law, these are the requirements of the anti-fencing law, which are not necessarily the elements of an accessory. Kasi di ba nakalagay sa anti-fencing law, dapat there should be a robbery or theft committed. Accessory is not limited to the crimes for robbery or theft. Ano pa? Second, that the offender knows or should have known that the items, no, in his possession is the subject of the crime of robbery or thievery. No? Or knows or should have known that the items, okay, are subject of the crime of robbery or thievery. This is not a requirement under as an accessory. Okay? Now, later on, malalaman nyo, they are exempted. Kung kamag-anak, no? Kung kamag-anak, exempted sila as an accessory. Pamaya, di-discuss na lang natin yon. Obstruction of justice from accessory. Ganun din. No? One is an SPL, one is an RPC. Good faith is not a defense in obstruction of justice, an accessory. Good faith is a proper defense. Ano pa? Obstruction of justice, it does not entitle the offender for a reduction of a penalty. In an accessory, reduction of a penalty 2 degrees lower than that committed by a principal. Okay? And obstruction of justice, malawak yan, di ba? Anyone who obstructs the prosecution or investigation of the one who obstructs the criminal prosecution, so obstruction of justice. Number 2 is if he also nag-impedes or impedes or obstructs the criminal prosecution or investigation of the offense. No? Now, ito yung sinasabi ko pala. No, pag Article 20, yung pagka ang number 3 ang gumawa nito, 2 and 3 ang gumawa nito ay relatives. No, relatives, they are exempted. Relatives of the offender because they are animated by blood. No? So, not liable as an accessory, but they can be liable for obstruction of justice. Okay, what else? A was bitten by a dog owned by a neighbor. The following day, angered by the incident, A took the dog without the knowledge of the owner, had it butchered and cooked the meat. He then invited his friends to partake of the dish with his friends who knew fully well that the dog was taken without the knowledge of the owner. What are the friends of A liable for? Theft, malicious mischief, obstruction of justice, or as an accessory? Liable as an accessory, no? Nag-profit sila eh. Okay. Questions as to number 3. Is it necessary that the principal of a crime be convicted first before one may be found guilty and punished as an accessory? No, it is not necessary that a principal of a crime be convicted first before one may be found guilty and punished as an accessory. Article 19 of the RPC does not require the conviction of the principal in order to convict the accessory. Okay, as long as it is proven that the crime has been committed, even if the principal has been arrested and convicted, accessory may be held liable. However, this principle is not applicable to the accessory under paragraph 3 of Article 19, where the principal was not tried nor was a final judgment rendered against him, because our paragraph 3 requires that the crime be proven as well as the identity of the author thereof. In which case, whether the principal is brought to court or is at large, the prosecution still has to prove the commission of the crime charge with the same quantum of evidence and the participation in it of all the persons indicated. I mentioned about Article 20, no? Accessories who are exempted from criminal liability. So, ang tanong, who are the relatives who are exempted? No? Ganun din. Wala lang relatives by consanguinity within the 4th degree. Okay? Yung spouses, ascendants, descendants, legitimate, natural, adopted brothers or sisters, hanggang relatives by affinity within the same degree. So, mother-in-law, daughter-in-law, pwede. Okay? Pero for as long as they do not profit from the effects of the crime. If they profited from the effects of the crime, they are not exempted. So DCB, the daughter of MCB, stole the earrings of X, Y, and Z. A stranger. MCB pawned the earrings with TBI pawn shop as a pledge for 500 loan. During the trial, MCB raised the defense that being the mother, she cannot be liable as an accessory. Will MCB's defense prosper? No. No, MCB's defense will not prosper because those who profited themselves or assisted the offender to profit from the effects of the crime are not exempted from criminal liability. And this is pursuant to Article 20. Okay? So, MCB, the mother of the accused, profited from the effects of the crime by pawning the earring. Tapos magtatago ka ngayon, nag-profit ka, nakinabang ka, ngayon sasabihin mo, hindi ka liable, hindi pwede yon. So, yan ang sinasabi ng batas. Let me just add a little more, no? Few minutes before we end. So mere possession of stolen property does not make the accused an accessory where the thief was already convicted. Entertaining suspicion that the crime has been committed is not enough. Okay? Knowledge of the commission of the crime may be acquired subsequent to the acquisition of stolen property. Of course, yung knowledge na yun can be proven uh, by circumstantial evidence later on. Yung clarification ko lang, yung subject acts of accessory, yung profiting themselves or assisting the offender to profit from the effects of the crime. The crime committed by the principal under this paragraph may be any crime, provided that it is not a light felony. Kasi nga, subject dun sa discussion natin sa light felony. Assisting the offender to profit from the effects of the crime. Tandaan nyo, no, dapat wala ulit conspiracy. Pag may conspiracy yan, ibang usapan na yan. Okay? Yung concealing or destroying the body of the crime to prevent discovery. There must be an attempt to hide the body of the crime. Okay? So yun ang yun ang importante. Kaya niya kinonceal or destroy yung body of the crime is to hide the body of the crime. Tatandaan nyo, doon sa pangatlo na yon, yung concealing or destroying, pwedeng maging liable dyan ay public officer at private. Pag public officer, ganun din, he assists, conceals, assists, or harbors the escape of the principal. The public officer acts with abuse of his public functions. No? Any crime, no? The crime committed by the principal is any crime. Provided, again, na hindi yon light felony. Baka pwedeng itanong sa bar yan. No? Tandaan nyo, sa light felony, hindi liable ang accessory as a general rule. Pag private persons ang nag-harbor ng conceal or assist in the escape of the author of the crime, dapat guilty of treason, parricide, murder, attempt on the life of the president, or known to be a habitual delinquent. So limited, pag private persons, limited lang doon sa sinabi kong mga crimes. No? Pwede posible ba na yung acquitted yung principal, makonvict yung isang tao as an accessory? Conviction of an accessory is possible, notwithstanding the acquittal of the principal. If the crime was in fact committed, pero the principal was not criminally liable because of what? An exempting circumstance. Insane yung taong, yung principal. Okay? Pwedeng mangyari yun. O kaya, minor yung gumawa. Di ba? Yung minor, nagnakaw ng isang relos. Okay? Tapos, yung nagkaroon ng accessory. Pwede yun. Kasi sa exempting, there's a crime committed but there is no criminal liability. Doon sa minor. Pero siya can be liable. Apprehension and conviction of the principal is not necessary for the accessory to be held criminally liable. So kung halimbawa ang principal is still at large, unknown, pwedeng maging liable and accessory provided the requisites prescribed by law for the existence of the crime are present and that some have committed the crime. Paano kung halimbawa, chinarge yung isa for the crime of murder? The victim, there was somebody who died, okay? And one was charged with the crime of murder, the principal. And X was accused of being an accessory to the crime of murder. Okay? Namatay ngayon yung principal charged with murder. So can an accessory to the crime of murder be found guilty later on? The accused cannot be held liable as an accessory under paragraph 3 of Article 19 if the principal charged with murder died before the trial, because had he been alive, he might have only been found guilty of homicide. Okay, siguro yun na yun. Accessory, distinguished from an accomplice. Number one, the accessory does not take direct part or cooperated or induce the commission of the crime. Second, the accessory does not cooperate in the commission of the offense, either by previous or simultaneous acts. Okay? At ang participation, third is the participation of the accessory in all cases always takes place after the commission of the crime. So just remember that. In other words, what are the things that you have to consider? The responsibility of an accessory is subordinate to that of the principal in the crime. Okay? Because his participation is only subsequent to its commission. And it is essential the fact that a crime is committed and by the principal, and his guilt is directly, and the guilt of the accessory is directly related to that of the principal. So, halimbawa, kung ang principal is acquitted because hindi naman na-prove yung crime, no? That the crime was not committed, or it does not constitute as a crime, the accessory is not liable. Again, but if the principal is acquitted because there is an exempting circumstance, ibang usapan yon. The accessory may be held liable as the crime had been committed. So, for as long as the crime has been committed, even if the principal has not been arrested and convicted, the accessory may be held liable. So, remember all those things. And again, yung mga exemption, tandaan nyo because we mentioned that a while ago. I think that will be all. No? So, thank you very much for attending. We can already end this record.